Hail there, legal warriors. Restitution. Why is that such an important part of a criminal case? How does it work if you're on the defendant side? How do you get restitution if you're someone who's a victim of a crime? Stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. I'm not just going to jump right into it. Restitution, what does that mean? Well, it's the principle that if you're the victim of a crime and you're out monetary damages, that you should be made whole by whoever did wrong against you. And restitution is a very important part of a criminal case for a defendant, believe it or not, because not only is it the right thing to do to make people whole for our wrongdoing, can also help you get a much better result in your case. So I'm going to go through a few examples of how restitution can help from the defendant's point of view. I'm going to go through some examples of how restitution is established and how it can be challenged if it seems unreasonable. And I'm going to go through from the victim's point of view about what maybe you can and can't ask for reasonably for restitution, and how it is that you actually can recover the restitution out of a criminal case. We'll cover a few more things too. That's just a little bit of a roadmap of where we're going to go with this video. So let's take a few case examples. The most classic cases where restitution might be owing would be a theft charge. Something gets stolen from a store, they're out those goods, and they're out enforcement costs of their security people. It could also be assault with there's medical damages someone suffered, malicious mischief, property damage someone suffered, things like that. And so in those cases, if we pay restitution for a non-felony charge, and it's not a domestic violence charge, those cases all non-DV, let's say, and the victim of the crime signed a statement saying they've been civilly satisfied for their damages, they've been paid, then your attorney may be able to bring a motion to get your case dismissed. There's something called compromise of a misdemeanor. If I remember, it's RCW 10.22.010. You can tell I use it a lot because I do not prepare for these videos. That it says that your attorney can file a motion with the victim's statement saying they've been satisfied and ask the court in its discretion to dismiss your non-felony, non-DV charge where there was monetary damages that you compensated the victim for. So that's a mouthful, but basically get your case dismissed. So that's great if that can happen. The court's going to look at your record and look at the overall circumstances, and your mileage may vary, but it's not an uncommon result in hit and run cases where there's property damage, theft cases, damage to other property, broken window, things like that. So that's one reason why restitution is really important for the outcome of your criminal case. Even at the felony level, certain types of prosecutors care a lot about restitution. You've got an embezzlement case. You have a case where there is a pattern of stealing from a store enough that it was a bigger number, more than a misdemeanor. Well, certain prosecutors will feel that not all of the wrong has been undone, but a lot of the harm has been lessened if the victim is made whole. And that may lead the prosecutor to give you a lesser charge. May take a felony down to a non-felony. May take a jail sentence down to a non-jail sentence. May take a case from a case to a dismissal. So we want to always, if we've got an ability to repay for what we've done wrong, we want to repay it. And paying restitution is not an admission of guilt. It can't be used against you. They can't say because the defendant paid this much money, if the negotiations break down, now that means that they were admitting guilt. No, they're just trying to settle the matter. Offers of settlement generally are not admissible in criminal cases. There's some exceptions going on right now, but that's not really about the settlement. It's about where funds came from and stuff like that. But we won't get into current politics. As far as what else restitution can do for you, can also impress the judge, right? If we don't get everything you want out of the prosecutor, you may get something you want out of the judge. Oh, well, you've paid this all back. Well, I'm going to be more lenient with you since you have. Okay? So that is really important. So what if the restitution amount seems ridiculous? And I'm going to give you an example that I lived through many years ago from the attorney point of view. There'll be no names here, but imagine a situation where a house got egged. The house gets egged, and then there's the owner of the house. Maybe they're a contractor. Maybe there's something else, plumber, who knows, there's something that knows something about the trades. And they claim way more damages than would be reasonably caused by the eggs. Hey, repainting makes sense, but repainting and doing no windows and also installing new gutters probably isn't harm that happened from the eggs, right? We didn't need new gutters from the eggs. So if there's a ridiculous amount requested or even a reasonable amount, we have the right to request a restitution hearing. A restitution hearing to fight about whether or not that amount of damages is reasonable and was caused by the bad actions of the defendant. And in some cases, the victim will get denied because it's not reasonable. And what we have to remember, though, practice pointer, that the judge is not limited to ordering the exact amount of the loss. The legislature has written the law so the judge can order, in most cases, up to 2 times the amount of the loss. So if, let's say it's a more simple case, a car accident or a hit and run. Well, let's say that they go to the most expensive body shop in town, and the body shop says $5,000, and you could get someone to do it for $3,500. Well, we're probably not going to argue for the $3,500 successfully because they can choose within reason where they want to go because they're the victim, and also the judge can order double our amount of $3,500. So if we say it's $3,500, well, I could order $7,000 anyway, says the judge, so I'm going with the $5,000. You get that? So that's the sort of, the practice pointer is when we're in the wrong, we're a little bit at the mercy of the system up to 2 times whatever amount it is they can prove. Usually they're just going to order the amount proved. They're not going to order double it. But when there's wiggle room, they can rely on that to go with the higher amount. That's oftentimes what we see. If you're a defendant, what if there is no restitution amount at the time that you resolve the case? Well, if it's a plea, they can leave the restitution open for a period of time. I see 6 months a lot. The restitution amount comes in, your attorney will be notified. You still have a right to fight about it, but oftentimes if there's not one at the time of resolution of the case, it probably never show up. But it could show up later if the court leaves it open. How do you pay restitution? Well, in some instances, if it's pre-resolution, you might work it through your attorney to pay the victim. If it's post-resolution, you might have to pay the court, and the court pays the victim. It depends. The court will let you know if it's post-resolution, how they want it done. So that's resolution from the defendant's point of view. What if you're a victim? Well, if you're a victim, you may be sent a sheet that says, what are your damages, right? Tell me what you're out financially. You might be able to use, I had to get a rental car. I had to pay for that. You might be able to use, because that was, you had loss of use of your car. I had to pay a deductible for my insurance, even though insurance covered it. They're not going to pay for your higher insurance rates if you have them. It's out-of-pocket stuff. I had to pay to go to the doctor. I had to pay to go to a psychologist. They're probably not going to let you pay for remedial measures for future problems. They're probably not going to say, yeah, we're going to make him pay for security cameras on your house, because that's a choice you're making after the fact. It may feel necessary, but they probably won't do that. You can throw it in if you want and see if it'll fly. It might. But basically, you're going to want to write down what financial harm you can quantify you suffered, not emotional distress. It's not about that. Restitution is literally money out and money back in from the wrongdoer. It's not, I suffered damages. That's for a civil suit. That's where people sue people for emotional distress and monetary damages. That way, not part of the criminal system. The prosecutor's job is not to do that. So if you haven't gotten that sheet to fill out, well, you might want to call the prosecutor's office. Say, hey, did you know I have some damages? Could I make sure you help me get this restitution? And prosecutors are busy, just like defense attorneys. They may forget about it. It may get lost in the mail. So go ahead and reach out and realize that I've already talked about it. You may have to justify your request later through a hearing where you might get called into court. So, try to be reasonable, treat yourself fairly, but let's not go overboard for things that don't really seem like it was an out-of-pocket expense, because you might get called on it. You won't get in trouble probably, but it's not going to be a lot of fun. So how do you get paid? Well, if it's pretrial, you might hear directly from the attorney offering to pay your damages. If it's post-resolution, most of the time, the court is going to take a payment in from the defendant and then send you the money. If you're the defendant and you have fines and restitution and you pay, usually the court's going to apply things to restitution first, so the victim is made whole sooner than the court is made whole for their costs that they incurred and the fines that they imposed on you. So that is why restitution is important from the defense side, and how you can get some from the victim side. One other thing for the victim, if it's a classic case of hit and run or something, and the other side as an attorney, maybe you could possibly reach out to the attorney and tell them about your damages. I would never probably reach out to the defendant. Usually better to go through the prosecutor, but depending on the type of person you are, you could try to do something directly. So I hope you found this useful. If so, please like and please subscribe. More people get the help they need. And even more importantly, if you have a criminal problem you need some help with, typically from the defense side, we do some victim work. Feel free to give my office a call, listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.